speaker today. I'm delighted that we have attorney Jason Brown with us, and he's going to talk to us about family law financial issues today. So take it away, Jason.
All right, thank you. Thank you, Sarah, and good afternoon, everybody out there in cyberland. When I first presented for the judicial branch back in January, who knew that 8 or 9 months later we would all be connecting remotely in this type of a way, rather than having in-person presentations and all the other fallout. But I know that you're out there. I appreciate the fact that you're here today and look forward to spending some time with you. I do want to just kind of reiterate that if you have questions along the way, please feel free to reach out. I want to make this as interesting and engaging as possible for you. Talking about numbers can sometimes have the preconceived idea of being kind of mind-numbing, but I'll try to make this interesting, try to make it relatable. I think the reality is that the vast majority of the folks that go to law school probably go because they're not stellar at mathematics. And of course there are exceptions, but what I have found is that the math part of family law can be somewhat intimidating as you sort of dive into the nitty-gritty on any particular case. But the good news is that family law and the math skills required to adequately address the issues in any file you might touch really are pretty low level. Some of the names given to things can be a little intimidating or confusing, much like reading a medical book would be intimidating or confusing to an outsider. But once you get familiar with the terminology and the methods by which things are done, it really is pretty straightforward. So I look forward to a good conversation with you all today. A little bit about myself, just so you know kind of where I'm coming from. If we haven't met, I'm Jason Brown, and I'm a family law attorney. I've been in practice now for 20 years, and I can tell you that it has been the quickest 20 years that I've been on the planet. They always say, and we always heard growing up, well, as you get older, time goes faster, and you kind of think, oh yeah, right, but it's true. I'm now in my late 40s, and I don't know where the time has gone. Throughout my career, I've worked primarily in the area of family law, presented at any number of seminars, including the Family Law Institute in St. Paul every year. I also write a monthly article in the Minnesota Lawyer. My wife and I co-author an article trying to highlight various opinions or cases or new legislation that's kind of come up and fun to kind of chat about. So if you ever want to check that out, you can certainly do that as well. So one other thing I should probably share too is that it wasn't that long ago I was sitting in your chairs. I clerked for Judge Timothy Bloomquist when I got out of law school. I spent a year with Judge Bloomquist, who's been retired now for almost 10 years, but it was a one-judge county, and so I had the privilege or the burden, however you look at it, of kind of diving into various facets of all sorts of things, including criminal law and real property interests, a lot of farming disputes, stuff along those lines. So we're going to talk today specifically about a division of assets and debts as it relates to a divorce. I'm going to hit this stuff sort of high level, hoping that this at least gives you a framework for understanding how these issues are handled in an accurate way, but then also in a very efficient way. I'd like to start with the premise that the law generally looks at assets as either being marital or non-marital. And that's the first broad distinction that has to be made in any family court case. So a marital asset, and when we talk about assets today, we're also talking about debts, anything that's a plus or a minus relative to the parties that are before the court. A marital asset or marital debt is something that was either acquired or accrued after the date of marriage, but prior to something called the valuation date. So it's this time continuum of, date certain at the front end, the date of marriage, and then the valuation date, which is something that is determined as part of a court action. A valuation date, just to kind of highlight further, is what I think of as a snapshot in time. It's typically, a moment in time that we gather all information and say, all right, this is the time and the date that we're using to look at balances and accounts, to look at the value of real estate, to look at the debts the parties might have, so that we're comparing apples to apples. Now, things are always changing. The stock market goes up every second. Bank account balances change from noon until 1 once someone goes ahead and gets their lunch. But we try to do this in an effort to at least capture with a decent amount of reliability, what the estate of a particular couple looks like on a particular time for purposes of dividing out their assets and debts. Now, of course, it has to be a little bit more complicated than that, and the complexity really rests in figuring out what will be the valuation date. Some parties will agree to use the date of their physical separation if they've been apart for a while. Some parties will elect to use the date for certain initial paperwork in a case, and still other parties are subject to various statutes or court orders regarding dates of different court appearances. In most counties in this era, when people generally now are diverted to something called early neutral evaluation, and they are given an opportunity to try to resolve their case outside the four walls of the courthouse, typically it's the date of that initial case management conference that is used as the valuation date. And if that date isn't ordered by the court or agreed to by the parties, the statutes say that the date of the first pretrial conference is going to be the valuation date. So it can be a moving target. But the important thing to understand for our purposes today is that there needs to be a valuation date, and it'll be up to either the statutes or the judicial practices in any given county or agreement of the parties to come up with what date is going to be used. One question that comes up a lot when I speak with potential clients, on the phone about certain things, is the question about whether the way in which a particular asset is titled is going to have any impact on their ability to receive a part of it. A common question, someone will call and say, hey, look, only my wife is the named title holder on the house that we bought 3 years ago. Does that mean I'm not going to get any equity? Or someone might call and say, hey, my husband has incurred $5,000 in credit card debt over the last 2 years on a card that my name isn't on. Am I responsible for a portion of that debt? And the answer is generally that anything that is acquired or accrued during the marriage, regardless of how title is held, is going to be considered marital in nature and subject to division between the parties. So the general rule is that timing of the acquisition, timing of the purchase is what's really going to govern, as opposed to who holds title. People will title things in their own name for all sorts of reasons. Maybe one spouse has a poor credit rating and the other spouse has a good credit rating, and they just decide to purchase a home in the better credit rated spouse's name to get a lower interest rate. Or let's say a spouse is out buying a car and they don't want the other spouse to have to take time off of work to drive down to the dealership and sign title paperwork. Any number of reasons that might happen. So timing versus title holder. So I mentioned earlier, the first broad distinction that has to come out between an asset or a liability is whether something is marital or non-marital. You may recall marital property acquired during the marriage before the valuation date. Non-marital property has some very specific definitions. And there's a statute that speaks to this along with a whole host of appellate decisions that kind of confirm the nature of non-marital property. But generally speaking, we're talking about property that is either brought into a marriage or is received as a gift or inheritance to one party, but not both, during the marriage. In other words, if someone's long lost uncle passes away and gives to them and them alone, $50,000, that $50,000 would be considered non-marital. There's exceptions we'll talk about in a minute, but generally speaking, that's what the law is looking at, is a gift or inheritance to one and not both, or the exchange of what is otherwise non-marital property in exchange for new property. Let's say that someone brings into a marriage a 1965 Ford Mustang, a classic, classic car. And after they get married, the individual with the car decides, well, I'm going to sell that car and I'm going to go buy a 1967 Chevy Impala. Now the Impala is non-marital if, of course, the Ford, the Mustang, was sold, the proceeds used from the sale of that Mustang applied to the purchase of the Impala. So it's anything you bring in, inherit, receive as a gift, or you exchange for otherwise non-marital property. Now, there are some nuances that really can bother the people who own non-marital property, and it's particularly prevalent in either bank accounts that are non-marital or investment accounts or retirement accounts. And the premise is this: the law says that even though a piece of property may be non-marital, any income that non-marital property generates during the marriage is going to be considered marital unless it is preempted by a binding and enforceable prenuptial agreement. Prenuptial agreements are not very common. They're out there. We draft them somewhat regularly, but I would say on a percentage basis, if I've been involved in, let's just say 1,500 divorces over the last 20 years, I would say perhaps 2 or 3 have involved a prenup. So generally the rule is that income generated from non-marital property is marital. What would that look like? Income from a non-marital asset would be something like interest earned on a bank account, or dividends paid from an investment account of one kind or another, or a piece of real estate, an apartment building that may have been paid for but generates rental income. So some get flustered by the idea that the increased value, in particular of accounts, some part of that anyway, can be deemed marital, even though it stems from a non-marital origin. But in addition to income from non-marital property can also appreciate, meaning it can increase or sometimes decrease in value over the course of a marriage. And so the question will often come up, will this piece of non-marital property, let's just say that it is a 401k plan. Question will come up. The 401k plan was worth $100,000 on the date the parties got married, and as of the valuation date, it's worth $200,000. And let's just say that there were some contributions made to the account, during the marriage. Obviously, the value of that account is increased if the parties have made contributions during the marriage. Those contributions are marital, but any growth on the pre-existing balance in the account would probably be considered non-marital because it would have been passive, what we call passive appreciation. There's active versus passive appreciation. If someone has a 401k and they're a day trader and they decide day in and day out, I'm going to buy Apple, I'm going to buy Chipotle, I'm going to sell Amazon, and then I'm going to purchase Microsoft, and they're a wheeler dealer with regard to the stock market. That would be considered something called active appreciation. Think of someone who's actively engaged in the management of whatever the asset is. And if the appreciation of that asset is the result of activity, of active appreciation, the court would consider that to be marital in nature, sort of like generating income on an asset that's otherwise non-marital in nature. Whereas if it's passive, if like most dollars were put into a 401k plan and those dollars just sat there throughout the marriage, the pre-existing balance was allocated, by risk tolerance as someone increases in age and they really didn't do anything but open that monthly or quarterly statement, that's passive appreciation. So that appreciation or increase in value would be non-marital and not subject to division. It's important to note that some assets have both a marital and a non-marital component to them. Someone brings a home into the marriage, right? And most people have a mortgage on their residence. And so on the date of someone's marriage, they have a certain amount of equity in the home, but the home isn't fully paid for. During the marriage, they spend down the mortgage principal using income, which is always considered to be marital in nature. And so that home now has both a marital and a non-marital component to it. And there's a formula to figure out how that combination or how that increase in equity, both marital and non-marital, is to be deciphered. It's called the Schmitz formula. There's a case in Minnesota, Schmitz versus Schmitz, that basically outlines how you run those numbers. And it's basically a fraction, whatever the percentage of equity over the value of the home was on the date of marriage, that percentage carries forward to the present value, with the balance being marital. Of course, there are exceptions, always is, but if someone refinanced the home during the marriage and they take equity out, are they taking marital or non-marital equity? Those are questions that can make it more complicated. The example I used earlier, the retirement account, that can have a marital and a non-marital component to it, where the account had a balance of 100 on the date of marriage, and then people added more money to it during the marriage using their income, which is marital. And at some point, we have to siphon through and figure out, well, what part of it is marital, what part is non-marital. Same with pensions. A traditional pension is based on typically a term of service. If you work for a union or a company or a government agency for X number of years, some of those years you were married, some of those years maybe you weren't. In that instance, there are some fractions and formulas that apply to dividing out pension interests. And business interests. This can be a really sticky spot for litigants who own businesses. They feel like they've come into the marriage with a business through their own blood, sweat, and tears, and they feel as though that business is theirs because they brought it into the marriage. But there's a case that's kind of a pinnacle decision in Minnesota called Nardini that speaks of the increase in value of a business during the marriage as being marital. So let's suppose that someone owns a plumbing company on the date of marriage, and they have one truck and no employees. And let's say at that point that business is worth, $25,000. It's one individual with a truck and some supplies. During the marriage, they grow the business, it grows, it grows, it grows. Suddenly they've got a fleet of 100 vehicles, revenues of $10 million, and 25 employees. The way that the law reads under Nardini is that the law considers that increased value in the business as being a product of marital efforts. And so the court would consider the difference in the value to be marital. If that business was worth, $4 million at the date of divorce, but worth $25,000, you've got a huge marital asset that the business owner may have otherwise thought anyway was non-marital. So we've talked a little bit about marital versus non-marital property. And so we've got to figure out, how is the court going to divide marital property? And the statute says it must be a fair and equitable division. The statute says that the court can take into account 7 or 8 different factors, including contribution to a particular asset and all these other things. Here's the reality of the situation. Equitable almost always means equal. And when I say almost always, I mean pretty much always. I was involved in a case that I thought would push the limits of this a little bit. I represented a client who was a pretty handy guy. And in addition to running a business, he knew how to build houses. And so he took it upon himself during the marriage to spend his off hours working on the party's primary residence in Maple Grove. And this was a beautiful home. He did a wonderful job. He literally, and I heard this repeatedly from him, so it'll stick with me forever. He literally connected the city sewer to the house. He literally did all the HVAC. He literally sprayed the ceilings, installed the plumbing, put on the shingle. I mean, everything from top to bottom. I mean, it's as though he was a sculptor and this was his art, right? And then because he finished the home and it looked so good, he decided he was going to build the parties at Lake Cabin up in the Alexandria area. And same thing, beautiful property, wonderful attributes. Wife files for divorce and says, well, you know, these assets are marital. And we suggest to the court that, no, this is an extraordinary circumstance. This is a circumstance where someone isn't making mere home improvements. I mean, this is a situation where someone has literally from scratch, you know, built something with their hands. We felt, you know, the argument was that the contribution that husband had made to the acquisition of that asset was so significant that the court had to give him more than half of the equity in both of those properties. And the court shot us down. The court cited the fact that there's some case law that suggests with a long-term marriage, there is a presumption that all property, regardless of effort, is deemed marital. And I think the undercurrent in the case was this, that even though husband was out spending all of that time building and using his skills and his knowledge to construct things that became very valuable, court basically looked at him and said, well, yeah, while you were doing that, your spouse was home caring for your 3 children. Your spouse was home enabling you to be out doing those things. The court considered it to be a team effort. So I have yet to find a case where anything other than equal is the rule of the day. Another case where this came up, a little bit different, but kind of similar. I represented a client who was a school district librarian in Minneapolis, and the pensions of teachers and other district employees is significant and is present valued at a lot of money. A lot of these teacher pensions, you may be surprised to learn, if you present value them through an actuary, are worth more than $1 million. And so this individual, this client who was a librarian, she'd worked for this district for 40 years and accumulated enough credits to retire, and she realized her pension was worth a lot, and she tried to argue that this pension was hers and hers alone. She was not giving any of it up. And I had to explain to her that it's not the way the law works, and she fired me and decided she was going to get better representation elsewhere, and came to understand that eventually that pension got divided by the court. There's really no real strong argument to do anything other than an equal division of marital property. Now, with regard to non-marital property, non-marital interests along the same line, I have found to rarely be divided equally between parties. And in fact, they're generally granted in full to the holder of that non-marital interest. There is an exception. The exception is that if the court finds some basis to invade non-marital property, the court can do that. What is a basis to invade? A basis to invade would be a scenario where you have one spouse who has, let's just suggest, millions of dollars in non-marital interests, and there is literally next to nothing in the marital estate, and the parties have been married for a long time. There's nothing there to divide, to give to the spouse without the assets. That spouse is going to need something to get going in life, try to recover and recuperate and make a go of things. And so in that type of a circumstance, the court has the inherent authority to invade the non-marital interest, to say, look, even though this is non-marital, it is fair, it is equitable for me as the judge to divide some of it, maybe not all of it, but give some to the soon-to-be ex-spouse so that they have an opportunity to recoup something from the marriage. But it is rare. I have not encountered this scenario either. So it's rare on both ends of the spectrum. Rare, nearly unheard of, to divide non-marital property. Rare, nearly unheard of, to disproportionately divide marital property. So there are some assets, of course, that have both a marital and a non-marital component, and those are items that I think of as hybrid property. Those are things like the house that has equity because of a mortgage pay down, but had equity also at the beginning of the marriage. So you've got real estate, you've got retirement, there can be stock options, there can be pensions, there can be businesses. And there are all sorts of ways to value the marital versus non-marital interest in these types of assets. I spoke earlier about the Schmidt's formula that talks about real estate. There's another case called the Sahlstrom case, and Sahlstrom stands for the proposition that there is a fractional mechanism to divide out stock options and things like that. Business interests, we kind of talked about Nardini, and the fact that you can define what the marital interest is by comparing the value of a business on the date of the marriage and the value of the business at the time that you've set for the valuation date. And the same thing with pensions. There's some fractional things that can be done to divide out what is marital, what was acquired during the marriage by way of the pension credits, and what was acquired either before or after the marriage to qualify for those pensions. So just know that there are these varying ways that these different assets can be valued. So here's an ugly word, but it's a word that's important to understand. It's called transmutation, and transmutation is generally not the holder of a non-marital asset's friend. And here's what it means. It references property that sort of loses its non-marital character based to, for lack of a better way of describing it, carelessness. In order to make a claim that something is non-marital, you have to show that that non-marital asset has been isolated and not commingled with marital assets. Let's say that on the date of marriage, one spouse has a savings account, and that savings account has $50,000 in it. They're a notorious saver. And let's say that throughout the course of the first 3 years of their marriage, the other spouse throws a bunch of money into that savings account. Let's say that the original account holder changes the account from an individual account to a joint account. Let's say then that after that 3 years of throwing money into that bucket, the parties decide to purchase an exotic sports car, and they decide to go on a dream vacation around the world, and they decide to buy a house. And they make home improvements, and basically whatever is in that account has now whittled down to next to nothing. The question is the next to nothing marital or non-marital? And without the ability to siphon out exactly which assets or which dollars were at one time non-marital versus marital. It's impossible for the court to draw a clear distinction about who's entitled to what. And we think of that as transmutation. I think of it as meatloaf. You take the pork, you take the beef, you pound it together, and you throw in some breadcrumbs and some ketchup, and you throw it in the oven. No matter how hard you try, you're never going to be able to siphon out all of the pork and put it back in its package, or all of the beef, or all of the breadcrumbs. Suddenly, everything is just merged together in a way that blurs the lines, which makes it really challenging to delineate what is marital and what is non-marital. That's important because the person who thinks something is non-marital has the burden of proving it. And if they can't prove it because they've got meatloaf, they can't prove how much of it is pork that they owned before the marriage, and that poses a real challenge for them. So that's the idea of transmutation. I mentioned the burdens of proof. The burden of proof is on the proponent of a non-marital claim. They've got to do something called a tracing. Tracing is kind of a fancy word for just saying you need to account for the non-marital interest that you're claiming. Some tracing cases are really, really easy. In particular cases where there's no transmutation, right? If someone has a savings account on the date of their marriage, and it's got $50,000 in it, and they keep that account isolated, and they don't ever deposit any additional money into that account, no income that would otherwise be considered marital, and let's say they earn no interest, 0% is sort of the going rate right now, and at the time of divorce, they've got $50,000 still sitting in that account. Well, the tracing in that fact pattern is very easy. You simply need to show the court that on the date of marriage there was balance, and then present all the statements that would show that there's been no activity in the account since the date of the marriage. That's the easiest example. It does get a lot more complicated when we're talking about residences, for example. Let's say someone owned a residence prior to the marriage, and the other side owned a residence prior to the marriage, right? They both sell their residences. They both take money that was non-marital, their equity from their premarital residence. They put a down payment on a new residence. So now they've combined their money. They have equity in the home, some of which is marital once they start paying on the mortgage, some of which is non-marital. They sell that residence, they buy a bigger residence, then they refinance that residence, they take money out, and then they sell that residence, and then they buy a condo and a timeshare in different parts of the country. Now the question is, all right, which parts of the condo and timeshare are marital versus non-marital? And it's enough to make your head spin. And so it's for that reason that we advocate that an accountant be hired, someone to come in with expertise to put together the formal tracing. There's a handful of folks in town who are really good at what they do. There are 4 or 5 different accountants that specialize in this kind of thing. And best practice from an attorney's standpoint is to bring in that tracing that's been prepared by an expert, because if you're able to have an expert opinion on it, obviously it's going to have more weight than merely coming in as a lawyer and saying, well, here's what we think it is, let's estimate what it is, and that can pose some challenges. So non-marital tracing, again, is the burden of the party who seeks to make the non-marital claim. I've tried on occasion when a client doesn't have a large budget to create my own tracing on things, and it seems to have failed miserably over time, and so I've just kind of stopped doing it. Kind of a classic example is I had a case where a client had a retirement account, and we weren't able to get statements that went all the way through the marriage. And so we didn't have the information necessary for an expert to put together an expert tracing. We thought we would do our best. We showed the court the balance in the account on the date of marriage, and we said, well, look, the stock market, the Dow Jones, on average, has gone up 53%, since that time. So give us credit for the balance on the date of the marriage, as well as 53%. And the court said, no, that's not good enough. You need to show us more than that. So important to understand that there tends to be expert involvement on those issues. And if you don't have experts, it's sometimes hard to navigate and give credence to what the lawyer is trying to argue on. So let's talk about some individual types of assets that are involved in divorce, and just hit on some of the high points involving how to value them and how to get them taken care of as part of the divorce decree. With regard to real estate, there are a number of ways to value a home or a piece of land. Usually, the best way to get a value is to have an appraisal done. The next best way, especially for settlement purposes, is to have a market analysis done. The difference is this: an appraisal is done by someone who is certified with expertise in conducting appraisals of property, to look at properties and give an objective assessment of what the property is worth. And they've got that sort of expert credential when they come into court by showing what their educational background is and all the work they've done. They're going to probably give the best, most reliable figure in terms of what a piece of real estate is worth. But if parties don't want to have an appraisal, they could talk to a realtor, and a realtor could come in and say, well, I'm looking at your house, and I know what houses are kind of selling for in this area, and let me run a couple of comps, and I'll do that, and then I'll tell you what I think we ought to list the property for. That can indicate value to a great extent, but it's probably not the kind of expert, if you will, that the court would want to give a lot of credence to, because realtors, they're somewhat notorious for increasing the value of a piece of property to entice someone to sell. It's hard for them to necessarily be as objective as an appraiser. They want the business, whereas the appraiser is getting paid already to do the work. Of course, parties can always agree to the value of a piece of property, or good old-fashioned look, if the parties can't market dictate, what the value is of this particular piece of property. And with regard to houses, one of the biggest challenges in a divorce case involves figuring out how to satisfy one party's equity in the property. For most parties, their largest asset is their home. It usually has the most equity, with some, there may be comparable equity in a retirement account or something, but for most, the home is a really big deal. And if one party is going to stay in the home, we've got to figure out, how do we get the other party the equity they're entitled to out of the residence? And in some cases, it means that the party staying in the home will take out additional money and pay them. Sometimes it means that the party who's vacating will get other assets of value as an offset to their equity in the property. In some cases, the party might receive a lien, in particular where parties have older children who are, let's say, 2 or 3 years away from high school graduation. We've had a number of cases where the parties have agreed that, or received an order from the court, that one party can stay in the home for a period of time until their kids graduate, because courts are always looking out for the interests of kids first. And then at that point, either sell, or the other party will have to pay them their equity, at that point. So various ways to do that. And if payment isn't made within a certain period of time, we often go back to court and get an order compelling the sale of the home so that the party can get the equity that they're entitled to. With regard to vehicles, not a lot to say here other than we typically use Kelley Blue Book value. Sometimes if it's like a classic car, we'll get an appraisal. Parties can often agree to values, or sometimes parties agree to sale. One thing to look out for is this: with Kelley Blue Book, you can always choose whether you're doing a private party value or a retail value, basically what a dealer would give you. And then there's also trade-in value. And most often, we look to Kelley Blue Book private party value as the measuring stick. And as long as you're using a consistent metric, let's say one party says, well, I want to use trade-in value because it's $3,000 less, and the other party says, well, I've used private party value, which is an inflated number. We just want to compare apples to apples. So that's something to look out for. Lawyers play this trick all the time. They'll come in and they'll say, well, trade-in value on this Cadillac is $8,000, and so it's worth $8,000, and it's really worth probably more like 12 to 13, but they're trying to get away with something. And it's okay to do that if we use trade-in value on the other vehicle sitting there. But most often, again, we just go to private party. Sometimes vehicles are gifted to children. If the parties have an older vehicle, they'll often agree that, look, we'll keep one vehicle apiece and we'll give our kids the other vehicle. And the reality is that a lot of vehicles are upside down, meaning that they're worth less than what's owed on it. You go to a car lot, you buy a vehicle, you take out a $20,000 loan on a $20,000 car. That car depreciates right away, but the loan doesn't depreciate, the loan stays. And in fact, you pay very little on principal during the first, year or so on that loan. And so some people are stuck with a car that's worth $20,000, but a loan for $25,000. And in that instance, what we often do is just say that, look, we're just going to call it a net zero. The car is worth what's owed on it. Because of the inherent nature of vehicle loans and the way that that works, we don't attribute negative equity to an asset on the balance sheet. Bank accounts are very easy to value. You just use monthly statements, and the nature of the account is really what determines the need for a specific number. And here's what I mean by that. If you have an account that is a savings account, an account that the parties routinely deposit money into and hold a balance, obviously we want to get a number for what the account is worth on a particular date. Some accounts, though, are more they're more transactional in nature, meaning that they they're an account used by the parties to deposit their paycheck, then they go to the grocery store, then they make a car payment, then they make their house payment, and suddenly their $2,500 paycheck leaves about $100 in the account. But then a week later, there's another paycheck deposited, and the balance goes up and down and up and down. We kind of think of those as transactional, and quite often what we do is just put those down as no value and award them to the party who owns them. At the same time, if they're a joint account and it's transactional, we will typically just say that the account will be closed, and whatever balance remains in the account at the time of closure will be divided between the parties. Investments, those are often dealt with through monthly statements as well. Not a lot to say there. Stock benefits can be a bit of a challenging category. There are values that are derived from looking at statements, but at the same time there are there's other types of stock accounts that can cause some confusion. The first is something we call stock option. Is an option where someone is an employee. Let's say they're an employee of the Target Corporation, and they're getting divorced, and at the time of divorce, they have an option to purchase shares later at a price that is hopefully lower than the stock price at the time they sell. Stock has gone up tremendously for Target. I had a case involving Target stock recently, and both clients, the client rather, was pretty happy. Both parties were happy because what was a $60,000 account is suddenly a $150,000 account. But in a situation like that, we need to value based on a fraction to try to figure out if there is some sort of equitable way to allocate shares that haven't been sold yet. So stock options, again, there's a formula that applies. Just know that there's a special formula that you use. We could talk for 20 minutes about how it all works. I won't bore you with that, but just know that if you see stock options, you need to understand how many options there are and when the schedule for exercising the options is and what the strike price might be, so that you can somehow figure out, at least with some sense of reasonableness, what kind of value we're dealing with. Compare stock options with restricted shares. These are shares that are granted at their, but they vest over time. It's a way to keep employees that are good at what they do within a company. The company might say, look, if you're with us 5 years from now, we're going to give you, 1,000 shares of Target. And if you're with us in 5 years, you can keep those shares and then you can sell them at the price of stock at that point in time. And so that's something that comes into play as well. The valuation of a business can be a really challenging piece. The couple takeaways from this are, number one, you almost always are going to need an appraisal done by a business evaluator as part of a court case. I mean, it's just a necessity. Businesses have so many moving parts to them that it's impossible to just speculate about what a business is worth. There are three primary ways that an evaluator will value a business. One is what you can think of as kind of a balance sheet approach, where instead of looking at the the nature of the transactions and the business and what's being sold and whatnot, the appraiser will simply look at the balance sheet and say, okay, what assets does this business have and what are its debts? And that becomes the value of the business. Let's say someone had a company that produces electric guitars, and they've got a machine shop with sanders and saws, and they've got a couple employees, and they've got a stockpile of wood, and they've got a stockpile of plastic, and they're going to go ahead and create these guitars. Let's say that business is brand new and they just haven't gained any traction regarding their brand of guitars. The value of the business at that point probably is going to be limited to its assets less its liabilities. But it does have value if there's inventory of wood, if there's equipment, things like that. The second way of looking at it is what we think of as a return on investment approach. And what that means is this: what would a willing investor pay to purchase a business? Without getting into a lot of details, generally speaking, if someone's going to make a risky investment, they want to get a high rate of return. And so generally the rule is a rule of 5. If one's business profits, let's say that the guitar shop makes profits after all expenses of $50,000 a year and does so consistently, that business might be worth 5 times its profits, $250,000. But maybe it's not. The appraiser has some discretion to sort of look at, all right, what's the market doing? What do other businesses look like that are selling comparable things? What's the balance sheet look like with this business? So there's always that sort of blurring and discretion. But that's a second approach or a second methodology that a business appraiser will use. And then a third approach is looking at comparable sales. What is a similarly situated guitar manufacturer, what is it sold for recently on the open market? Appraisers have access to all sorts of databases, and they can look up those numbers. And quite often what they'll do is they merge and combine and look at the economy as a whole, and they look at a lot of different things to figure out, what is that business worth? So it sounds easy to get a number, but then the other side hires their own business appraiser, and all of a sudden you've got the battle of the experts. So what a lot of people do, because business appraisals can be expensive, is hire a joint neutral appraiser. With regard to life insurance, just understand there's a distinction between a term life policy and a whole life policy. A term life policy is your basic life insurance where you pay a premium every month, and if you die, someone gets the cash out. Whereas a whole life policy is one that you pay a premium for, but it also has cash value beyond the mere policy. So understand that some policies are going to have a value listed on the balance sheet. Those are whole life policies that have a cash value subject to verification of the value. And a term policy is just kind of a rental policy. It's gambling. If you pay a premium, if you don't die, they keep your money. If you do die, they pay out. Credit card debts, unsecured debts, they're often verified by monthly statements. Quite often we have to siphon through and figure out if people have put attorney's fees on their credit cards and remove that from the equation, because the law generally says each side is responsible for their own, unless there's some independent reason for a need-based or a conduct-based claim. And we often see different valuation dates for debts versus assets. If the parties separate 6 months ago, but their initial case management conference doesn't happen until 6 months later, any debts they've incurred during that period of separation quite often are going to be considered to be their own separate debt rather than part of the marital estate, even though the assets are going to be valued as of the date of that initial case management conference. One particular type of debt that is worth noting, student loans. And there are a lot of people with a lot of student loans out there. I can tell you based on just my own work that a lot of people have many tens of thousands, if not more, in student loan balances that they're carrying. And but the question here is a student loan marital or is it non-marital? And student loans are sort of a unique debt in the sense that the character of the loan, whether it's going to be something that the parties are going to share or something that the holder of the loan will continue to be responsible for on their own, is determined by how the funds were used. Now, if the student loan was brought into the marriage, much like an asset, that was acquired prior to marriage is non-marital, so too is a student loan debt, right? A debt brought into the marriage is going to be considered non-marital and not subject to division. But if a loan was incurred during marriage, the court will generally look at were the funds used to pay books and tuition, or was some part of the funds used to pay what are otherwise marital expenses, things like groceries, gas in the car, daycare expenses, house payment, rent, etc. The part of the loan that went for routine living expenses is going to be deemed marital, most likely. The part that went for books and tuition and so forth, most likely, even though incurred during the marriage, would be considered non-marital or the responsibility of the person who incurred that debt, because they're getting the benefit of that debt throughout their lifetime, the education. Tax refunds and liabilities, the general proposition here is that they are subject to equal division regardless of income level. So if one spouse makes $400,000 a year and the other makes 40, they both realize the benefit of that income during a given year, and so they're each either responsible for half the tax debt or they get to realize half of the tax refund. That irks some people, but generally speaking, because income is considered marital, so too are the tax consequences. This is a nuance issue, but it comes up from time to time. A personal injury award, is it marital, is it non-marital? It's determined by the nature of the recovery. If someone is in a car accident, and let's say that they suffer a loss of their hand, and they're out of work for a year, the part of the personal injury award that relates to the hand, the injured part that is technically premarital because you brought your hand into your marriage, that's going to be non-marital, whereas lost wages during the marriage, any recovery made for lost wages that would have otherwise been marital in nature is marital as a result of the award. The problem is most personal injury cases are settled and most don't have a specific breakdown with divorce in mind, so it can be a challenge. Couple last points, and then I'm going to open it up to questions. Real quick, spent money. Some people want to argue about spent money. My spouse 2 years ago went on a vacation, didn't take me, and spent $50,000 in Las Vegas. Can I get that money back? The answer is no. The court is not going to re-spend the party's money. With regard to household goods and furnishings, the court is generally not interested in getting involved in dividing plates and spoons and furniture and all that kind of stuff. We typically refer parties to arbitration and help you in that way, because we know that you and the court generally has bigger fish to fry. With retirement interests, keep in mind some accounts are pre-tax accounts. In other words, a 401k plan hasn't yet paid tax on the money in the account. And so you need to often siphon out assets and figure out which are pre-tax and which are post-tax and value those retirement interests based on monthly statements. There's some more stuff here about pensions. I'm kind of at the point where it's about 5-2 and I want to take questions, but just know there's a few distinctions on pensions and you'll get a copy of the slides. And again, if you have any questions, you can certainly give me a call. the concept of dissipation is a waste of marital assets. The key here is in contemplation of divorce. Some people come in and say, my spouse went and wasted a bunch of our money. Can I get reimbursed for that? And sometimes the answer is yes. Sometimes it's no. And finally, balance sheets. I hope to kind of work through a balance sheet with you today. I won't be able to, but if you have any questions about that, I can certainly send out the sample balance sheet that I was going to use today to show how this works. But balance sheets are a great way on a single sheet of paper to put columns in an Excel spreadsheet for what each asset is, what it's worth, who owns it, who it's being allocated to, and then you can add up all those numbers. You can figure out who's getting more than the other. You can then figure out what is the equalizer that needs to be paid, or how do we allocate the assets so that each party is made whole. And you often can attach that to a divorce decree to serve as a real quick way to look at that and see what's there. So here's what a balance sheet would look like. Again, if there are questions, I intended to kind of walk through some of this, but we're running short on time. So with that, are there any questions? And I've said a lot, I apologize.
If you guys have questions, please enter them in the chat, and I can relay those. I don't see any yet, but we'll give people a moment to type here. I suppose one question that I have, just related to this, you mentioned getting a court order for enforcement. What's the reality of actually being able to recover any money if it's not being appropriately paid?
Are you thinking like if someone isn't paid their equalizer from someone who was supposed to refinance a piece of property?
Yeah.
Mm-hmm. Well, the remedy, and I've had this a few times, most recently about a year ago, the other side, in that case it was husband, I represented wife, he was supposed to pay her within 90 days of entry of the divorce decree. She was going to receive $60,000 or something. He didn't pay her. And so we had to, well, we worked with him first. I mean, and I'd like to think that most reputable attorneys are going to try to work on this stuff outside of the courthouse proper. We tried that. We tried to be nice. We tried to give him some extra time. It just wasn't working. He was a snail, basically, just chugging along as slow as he can. So we did go to court. We filed a motion asking that the court give him 30 days to make payment, and if not, give our client discretion to list that home for sale without the need for signature on the part of the spouse that remained in the home, the husband. And we were successful in doing that, and that's what in fact wound up happening. Was the home did get sold, and she got her money that way. So
okay. So we do have a few questions that have come in on the chat. First one we'll take: what about property gained when the couple is dating and then gets married?
That is a good question, and we get it a lot. And generally, the law siphons out marital versus non-marital. The law also, in a roundabout way, addresses what is to happen with cohabitants rather than married couples. The law on cohabitation is not very well developed. In fact, it wasn't well developed 20 years ago. I initially had some cases involving it, and there was some controversy about the way that the Court of Appeals at one point handled some cohabitants. The way the law, as I read it, generally says whatever contribution parties make to a particular asset while they are cohabitating gives them that fractional ownership in that particular asset. So if parties cohabitate with each other prior to marriage, one party makes all the house payments, the other party makes all the electric bill payments. There's an argument anyway that only the person who made the actual house payment is the one who has an interest in it. Most often, though, we're able to resolve the issue by reaching some sort of a compromise on it. But it's a good question. And And I think that the law does need to develop a lot more with cohabitation, because now there are so many more people who are cohabitating, and with little to no law to protect people, which is what the dissolution, the divorce statutes are designed to do, is protect people's interests. People are just sort of swimming in the ocean and hoping for the best. Part of me thinks that it's because, generally as a society, marriage has been encouraged as sort of a pillar of stability. And so the legislature has said, yeah, we'll protect you if you get married, go get married. We want that. But they don't offer much protection to cohabitants. But maybe we can get that changed at some point.
So we're at time. We have a few more questions, and Jason, I don't want to impose on your time if you need to leave, but
Oh, no, I'm good. I'm good. Let's,
okay.
Anybody
So
else is interested?
sure, yeah. So I'm sure a few people will need to step out, but we'll continue answering questions here. There has been a request to receive the slides and a copy of the balance sheet. If you're willing to share those, I'll send those out to everybody.
Absolutely.
Great. All right. So the next question: if you had a prenup and lost it, but both agree it existed, is that sufficient?
Well, if the parties agreed it existed, and if they went to court, and well, back up. I mean, it's a case that probably would get resolved if they were agreeing that it existed and they agreed to implement its terms. But if they're both saying in court, if one side is compelled to acknowledge, yes, there was a prenup, but there's no copy of it, I'm inclined to think that there wouldn't be any contract that could be enforced because it doesn't exist on paper. I'm going out on a limb here, but I'm thinking back to the restatement second of contracts. I think it was 110 that talked about statute of frauds. There needs to be written contracts regarding certain things, including real estate and a bunch of other stuff. So I'm inclined to think that unless the parties, if they want to voluntarily agree to it and settle the case, I don't think the court's going to mind at all. But if one party comes in and says there was a prenup, and the other side, yeah, there was, but they don't have it, and the one party says that's not what it said, I think all bets are off.
Okay. A couple more questions. One, any tips on valuations of workers' compensation settlements?
Work comp settlements. I think that you'd have to look at them much like a personal injury settlement. The nice thing about a work comp settlement, if I recall correctly, is that work comp does delineate how much is for a disability rating, like pain and suffering, and then they'll have like temporary total disability, permanent total disability, and those all relate specifically to the body itself. Then there are parts of a work comp award that are for the lost wages and things like that. If the wages were lost, the wage loss stems from stuff during the marriage, that part of the award would be marital because the parties would have shared the income anyway. But if the work comp award pays something into the future, where someone's going to continue to get money after the divorce when parties are not married or after the valuation date, that part of it would be non-marital. So basically, I think you just would want to look at the work comp as it relates to the rating on the disability, and then the amount that is specifically outlined as being for wage loss and the character of that wage loss.
Okay. And then the last question that I'm seeing here is, what if the couple's kids are halfway through college? Is the rest of the tuition throughout graduation a shared debt?
No. Let me think on this now. A couple scenarios that have come up. The first, this is kind of a fundamental premise, that once a child emancipates and they graduate and get out of high school, the court loses jurisdiction over them and cannot obligate anyone to provide support for that person. So while it has become very common, and rightfully so, that students will continue to kind of hang their hat at home while they're in college and so forth and continue to get financial support from their parents, there is no legal obligation for a parent to do that. So the court can never impose upon someone an obligation for a parent to pay a college student's tuition or books or anything like that. Now, if the parties agree to do that, if the parties said, yeah, we will agree that we will divide all college-related expenses, and that gets incorporated into a decree, the court has the authority to approve the agreement of the parties. And so in that circumstance, absolutely, you could enforce that agreement, even though the court didn't have the authority to do it on the front end. And then a third scenario that I've seen play out is if parents take out student loans on behalf of their children or they co-sign. By co-signing, they are jointly liable for the loans with their child. And so, they may be on the hook at some point, and the court would probably consider that to be a marital debt or at least a marital risk. But if the parent alone takes out loans or the parties take out loans, I've had that happen once or twice. And in one case, unfortunately, one of the spouses, my client, didn't know the other parent took out loans in their name. We ultimately came to a settlement where the party who took out the loans took responsibility for the loans. We were able to negotiate, but I haven't been in front of a court to have a decision on the scenario where one party, without the other side knowing, takes out a student loan for their child and then alleges that that other parent is now responsible for half of it. It's a competition, I suppose, between equity and knowing that courts can kind of do equity in any circumstance, and the idea that a debt accrued during the marriage is generally marital unless there's some really good reason for it not to be marital. So I hope that answers the question.
I think so. I think that's all the questions, so we can go ahead and end there. Thank you so much, everybody, for logging on today.